I'm going to keep this to a very short introduction because the less I speak, the more they do, and that's the point. But I am so happy to be able to welcome today Juliana, Olson and Phil Gregory. Julia is the chief litigator in this amazing lawsuit, Juliana versus United States, and she's also the executive director at Our Children's Trust. I hope she's going to talk a little bit about that because it's such a fascinating program. And Phil Gregory is the principal at Cockpit Pitcher and McCarthy, if I pronounce it right. He has so many levels of expertise that he could have talked to us the entire 3-day conference. I'm pretty sure he's going to stick to Juliana v. US today. So please join me in welcoming Julia and Phil.
All right, so I'm going to try to talk without the microphone. Is this going to work for everyone in the back?
Yeah.
Yeah? Okay. If you can't hear me, let me know. So it's really a pleasure to be here, and I want to thank the Global Justice Conference organizers, and especially Thomas Pogge, for inviting us to come and talk with all of you at the conference today. So I founded Our Children's Trust in 2010. And I did this in response to practicing environmental law in the statutory realm for about 12 to 15 years, and I had children. And I had been working on climate change, but when I had kids and realized what our lack of effectiveness as public interest environmental lawyers, I decided we needed to do something different. So the mission of Our Children's Trust is to elevate the voice of young people, because they have the most to lose right now in terms of the living generations, and to give them the ability to secure their fundamental legal rights to a climate system that will sustain their lives and the lives of their posterity. And so in order to do that, we give youth the opportunity to bring legal actions against their governments, to enforce government duties, to protect them from dangerous situations and not to cause dangerous situations to them, and that's really important. We'll talk about that more in a bit. And the other part of our mission that's really important is that when we compel governments to act, that the actions need to be based on the best available science we have today in terms of what's happening to the climate system. Because if our policies on climate and energy are not paying attention to the science and they're disconnected, we will not stop this catastrophic global crisis that we are in right now. So science-based is also really key. I show you this slide because a lot of the efforts have gone into international agreements and treaty making and trying to get the global community to come together and do the right thing. And the problem with that is that we haven't had the ability in many countries, like the United States, to enforce those agreements. And as was discussed this morning, I think it was Julia was mentioning that the United States has really been at the heart of causing these international processes to fail and not be as meaningful as they could be. So in addition to working in the United States, we work at the state level, at the federal level. We also support international youth in bringing legal actions against their governments. And the bases for the cases vary depending upon the laws available to us, but they're all fundamentally rooted in human rights principles and in the principle of the public trust and government's obligations to its citizens. And so we can talk a little bit more about our global work, but we have active cases in India, Pakistan, Uganda. We're supporting the Portuguese youth who are going to take the European Union countries before the European Court of Human Rights. And we're supporting new actions under development against the governments of Canada, Australia, and one other one I shouldn't talk about because this is being recorded. But really what I'm here today and what Phil and I are going to be talking about is the Juliana versus the United States case. I just want to mention before I go there one other exciting case that we launched yesterday against the state of Alaska and the governor and its core departments and agencies. This is an Alaska state constitutional case to enforce the constitutional rights of young Alaskans, including Alaska Natives, to a climate system that sustains their lives. And those are some of our plaintiffs and petitioners in that case. But turning to Juliana versus the United States, what we really want to have with all of you today is a constitutional conversation about climate change and protecting our young people. And what we did in August 2015 was file a suit not against the Trump administration, but against the Obama administration, the United States, and the core executive agencies and departments that are responsible for causing climate change. And this case, it's not political. It just so happened that 2 days before we got one of the most important decisions in the cases, Trump was elected president. So now all of the new president's secretaries have been substituted into the case as defendants. And at the beginning of every constitutional conversation, it's a story of the people, right? And so at the heart of any case is the story of the plaintiffs. So I want you to meet some of our plaintiffs in the case. There are 21 of them, but this is Jaden. Jaden lives in Rayne, Louisiana. And in August, a year ago, right before we had oral argument, Jaden woke up, she stepped out of bed, and she was up to her ankles in stormwater in her home and sewage running through her house from the floods that were happening in Louisiana. Even though she lives outside of the floodplain, and this was a so-called 1,000-year flood event. In Jaden's words, she says, a few weeks ago, I literally stepped out of my bed and was up to my ankles in climate change. As we saw from this fall, we've been in one of the most significant hurricane seasons in recorded human history, where the cyclone energy of the hurricanes was 3 times that the scientists have recorded in the past. And this is Levi, who lives in Idialantic or Satellite Beach, Florida, which is a barrier island off of the Atlantic coast of Florida. He lives at 3 feet above sea level. And according to government projections, by century's end, his island will be underwater. But even before that, within the next 2 decades, his home is going to be unlivable because of sea level rise and storm surges. And the government projections, by the way, that come out of our National Oceanic and Atmospheric Administration, they don't take into account the rapid disintegration of ice sheets that happens in these sea level rise pulses that we can show through the paleo record. And I'll talk a little bit about that. This is Jacob. He's a young farmer in southern Oregon. And I live in Oregon, and this summer we had weeks of just smoke-filled air. Our air quality was like that of Beijing. We were in the danger zone. So he farms on his farm wearing a mask. It's excessive heat and temperatures and drought conditions threaten his farm, and wildfires nearby. And then, of course, California wine country, the massive fires down in Santa Rosa. And this is Zealand, who was impacted by these fires. He lives in Oregon, but his family lives in Santa Rosa. And Zealand's grandmother lived at the Journey's End Trailer Park, which was burned down in the fire. Most of his family in the Santa Rosa area was displaced. They're suffering health impacts as a result, and his grandmother doesn't know if she will ever be able to go back home. So those are just some of the stories. And what's interesting is each of those stories I just told you happened since 2015, so after we filed this case. And one really important part of the plaintiff's stories in a case is that they help establish standing for the plaintiffs to be in court. So plaintiffs have to be injured, for those of you who aren't lawyers in the room. And all of our plaintiffs have stories of harm and injuries from climate change that precede 2015. But as you can see, it's just getting worse for them. So now I want to talk a little bit about some of the core factual components of our case and walk a little bit through the science part of the story. It's really important, again, because we're working from a science-based perspective. And I show you this image of global emissions because I want you to notice that 1950 is sort of the midpoint, right? And shortly after that is when we really saw the acceleration of fossil fuel consumption globally. And the tracking of what fossil fuel burning was doing to the planet started well before NOAA started measuring it in the mid-50s in Hawaii. It started by a man named Callender, and he started doing more crude measurements to measure CO2. But as you can see, the Callender and the Keeling curves combined show this trajectory of carbon dioxide emissions going up. But to me, this is one of the most important contributions of science because it shows the correlation between carbon dioxide concentrations in the atmosphere, global temperature, and sea level rise. And you can see how they match one another. And what I want you to notice in that top right corner is, with it circled in red, is this. So over thousands and thousands of years, carbon dioxide levels, they fluctuated between 180 parts per million and 280 parts per million up to the Industrial Revolution. And just in the last, a little bit over 100 years, we have increased those rates by over 120 parts per million within such a short window of time that nothing like this has happened in the paleo record. And that has resulted in a 1 degree Celsius increase in temperature. And this just gives you a little bit of a visual image. I'm sure many of you have seen it. It's a NASA video. But I think it's important to understand visually how this heat is affecting the planet. And one way I like to talk about it is, imagine, so 1 degree Celsius is about a 1.8 degree Fahrenheit increase in temperature. And imagine if your body baseline was over 100 degrees Fahrenheit on a consistent basis, right? So not 98.6, but 100.2, and you had to live in that space. Very small changes in temperature have profound impacts on living systems, and it's important to remember that. So this blew my mind when I finally figured that reading scientific articles and talking to our experts, that over 90% of the excess heat that's in our system is being absorbed by our oceans. And that's why ice melt and sea level rise is such an enormous threat. And if you think about all that water on the planet and how much water holds heat and for how long, it begins to tell you a little bit about the urgency of why when we lock in heat to our oceans, it's going to be there for centuries, and many future generations will have to live with that heat. And of course, it's causing ice melt. So Eric Ringno, who is one of the experts we work with, talks about the rapid disintegration of the ice sheets they're seeing both in Antarctica and Greenland. And this really is an important part of the scientific story that we're telling and that we will present as evidence in court. Because the last time carbon dioxide levels were over 400 parts per million as they are now, the seas were 70 feet higher than today. 70 feet higher. And so this gives you a little bit, it's not a great image, but it gives you a little bit of a sense of how our coastline would change with 70 feet of sea level rise. So we haven't experienced that 70 feet yet because it takes time for the ice to melt, which is why there's still a window. If we can pull back our CO2 levels to a safer level, we might be able to avoid some of this catastrophic ice melt, which is what we're trying to do in this case. So there's a quote from the complaint here, and it says, as sovereign trustees, the affirmative aggregate acts of defendants are unconstitutional and in contravention of their duty to hold the atmosphere and other public resources in trust. That comes from our public trust plate, but it kind of gets at this core concept that sovereign governments, they have duties to the people. And what has our government, the United States government, done? Well, they haven't sat back and done nothing. And I want to be really clear, this is not a failure to act case. So a lot in the legal realm, there are these failure to act cases. And this is not that. This is a challenge to the affirmative, systemic, and aggregate acts acts of the United States government to cause and contribute to climate change. And these give you like some of the images of the ways in which our government does this. But we have a national energy policy. We have national energy plans. The federal government leases extraction and authorizes pipelines and transmission lines. We subsidize the fossil fuel industry. We financially support them in many ways through research and development. It was the Department of Energy's research that allowed fracking to take off. It wasn't industries, it was the government's research. So we've put together this story of all these actions. And we've brought a constitutional case under the Fifth Amendment of the US Constitution. And I'm going to let Phil sort of in a few minutes walk through these claims in more detail, but I want to give you just the big overview for a moment. So under the Fifth Amendment, it protects our rights to life, liberty, and property. And the government doesn't have an obligation to act to protect you from some third-party harm. But it does have an obligation not to infringe actively on your rights to life, liberty, and property. And so the first claim is called the state-created danger claim, and it flows from Supreme Court case law that Phil will talk about. And the second core claim is really the infringement of these young people's rights to life, liberty, and property in some cases. And then the third claim is about discrimination against children as a class of people with respect to their fundamental rights. And so that claim is a combination of substantive due process rights and the equal protection principles from the 14th Amendment. We've also brought a public trust doctrine claim, as I mentioned, and this claim is also brought through the Fifth Amendment, but it's about the federal government's trustee obligations to its citizens to avoid substantial impairment of public trust resources, which include water and air, the shores of the sea, and the sea, all of which our federal government exercises control over. So initially, when we brought the case, we sued the federal government, but industry wanted to come in and participate, so they intervened as defendants through the three big trade associations. However, after being in the case for almost 2 years and losing, they decided they wanted out. So they actually moved to withdraw from the case, and were granted the ability to withdraw this past summer. But while they were in, both the government and industry brought motions to dismiss. And the green ones are the arguments that the federal government made. So they said the youth don't have standing to be in court, they can't show that they're injured or that the federal government caused it. And they said these youth don't have constitutional rights, and the federal government has no public trust obligations. The interveners made those arguments as well, but brought in some additional arguments related to the political question doctrine. And the political question doctrine is about separation of powers and that certain things should be left to the political branches of government. And there was an interesting moment during oral argument a year ago when the Department of Justice was arguing to the federal judge in the District of Oregon that plaintiffs have brought a great case. Climate change is a big problem. There are real issues here, and they should be making this case to Congress. And the court stopped him and said, it has been heard in the halls of Congress, and the political branches are not doing what they need to be doing to address this very significant crisis. So Judge Ann Aiken, 2 days after the presidential election, issued a decision denying the motions to dismiss in full and allowing the case to go forward. And I want to highlight two really important legal holdings she made in that decision. The first was she recognized a new fundamental right under the US Constitution and the Fifth Amendment, under the liberty prong of the Fifth Amendment. And then the right that she recognized for the first time in our history is the right to a climate system capable of sustaining human life. And she said, where a complaint alleges governmental action is affirmatively and substantially damaging the climate system, it states a claim for a due process violation. To hold otherwise would be to say that the Constitution affords no protection against a government's knowing decision to poison the air its citizens breathe or the water its citizens drink. So this was monumental. I want to point out that that new fundamental right that she's recognized, even if higher courts did not agree with that, we have other claims that would still go forward based on rights that have already been recognized by the US Supreme Court. The other thing she did is she said the public trust doctrine is not just a doctrine that applies to the states, it also applies to the federal government. The federal government is a sovereign and therefore it has trustee obligations. And she relied on one of the most famous public trust cases in the United States is Illinois Central Railroad versus Illinois. And in that case, where the city and the state, they were going to give away the harbor of the city of Chicago, the court said giving away the shoreline of a great waterway would be a grievance which never could be long borne by a free people. Which, you know, if you think about what's happening today, it's not just giving the shorelines to a railroad company, but giving our shorelines literally to third-party interests and companies that are using our atmosphere as a dumping ground and causing our seas to rise. So, but I'm going to do one more slide before I turn it over to Phil. So we like to do this dog and pony show, something like that. And I want to point you to James Madison, who drafted the Fifth Amendment to the US Constitution, and he was our fourth US president. So in 1818, right after he completed his term as president, he was speaking to an agronomical society. Because James Madison, much like many of the founders of the United States, were farmers, and they cared deeply about soil and land and place. And one of our experts pointed me to this speech, which she sees as a founding document of our country. And I was blown away when I read this, because James Madison in 1818 was talking about climate change. And he said here, as you can see, that for animals and man and plants, to all of them the atmosphere is the breath of life. Deprived of it, they all equally perish. And the reason why this is important and why I'm holding up to you a man who was also a slave owner, because these were imperfect men. But our Supreme Court and our federal courts, they look to our nation's history and traditions when they define the scope of our liberties and what they mean. And so looking back to James Madison, who drafted the Fifth Amendment and was talking about how important nature was and how important the atmosphere was to the very liberties that the founders were trying to protect, is central to our case and gets at this story of originalism that is very compelling and important for conservatives as well. So with that, we're going to do a deeper dive into the claims, and here's Phil.
So again, we're going to start with the Fifth Amendment where Julia left off. What are our constitutional claims? And to do that, again, remember the Fifth Amendment guarantees that citizens will not be deprived of their rights to life, liberty, and property without due process of law. So what do our claims assert under the what's called the substantive due process? Well, what we're essentially going to prove in court, is that the federal government has known for over 50 years about the issues concerning these greenhouse gases and the effects that the systemic fossil fuel emissions will have on the youngest and future generations. And this is really important to understand. the federal government has known and has acted affirmatively in light of that knowledge. Well, okay, so how do we prove that in court? And what precedents are there? What other decisions already exist that can guide our judge in Eugene, Ann Aiken, to reach a result in favor of our youth plaintiffs? Well, I want to talk about in particular two cases. One is a case called Henry A. versus Willett. And the Henry A. case is a very tragic case. It arises out of Nevada. A prior case arose out of the state of Washington. And what occurred there is kids were placed in foster homes when the foster care system knew that the kids were likely to be abused if they were placed in the home or with the foster parent. Either physical abuse, not getting fed, not getting medical care. The foster care system knew or strongly suspected that these kids were going to be affected this way, and yet placed the kids with the foster parent who then abused the children, or put them in a foster home that totally neglected the kids, allowed abusive parents to come in and beat them up, everything along those lines. And the Henry A. opinion says those kids have a claim against the state because the state created the danger. The state put them in harm's way. And I'm going to read here from the Henry A. decision. It says, have the affirmative acts of the state placed an individual in danger, whether the danger was known or obvious, and whether the state official acted with deliberate indifference to the danger. I think we would all agree that if a foster care system knows that someone is going to abuse a child, or strongly suspects that a child is going to be abused by a foster parent, and puts that child with that parent, or puts that child in that foster home, that the state should have responsibility to the child. And that's exactly what the court in Henry A. said. You, the state, have responsibility. A similar situation involved a gentleman by the name of John Castro. And John Castro, unfortunately, one night, he got a little too drunk. And the cops picked him up, and they put him in a holding cell, a place for him to, in essence, sleep it off till the next morning. Well, another guy, we'll call him the bad guy, also was drunk. And when the cops picked up the bad guy, they put him in the cell with John Castro. Now it turns out the bad guy, the cops knew, make sure you understand, the cops knew that the bad guy, when drunk, had violent tendencies. He beat people up. So they put the bad guy in a cell with John Castro that had no ability for Castro to communicate to the outside, and then they didn't check on him for a half hour. Well, a half hour later, they come in, Castro's been beaten near to death by the bad guy. And the question is, well, can Castro sue for a constitutional violation? Can Castro bring a claim against the police who put him in the cell with the bad guy who then beat him up? And the courts have said absolutely. And there's two reasons for that. Obviously, because they knew that the bad guy was going to do was likely to do these things, but also because the state knew that it had the ability to make changes to drug cells. They could have put in cameras. They could have had it open so you could hear what the people are saying. They could have checked on them more frequently. There's a lot of things the state could have done but didn't do. And as a result, Castro was severely injured. And so the issue in this case, in the Castro case, is can a plaintiff, or I'm going to put these language for our kids, can our kids establish that facts were available to, and I'm again paraphrasing, the federal government, that put the federal government on actual or constructive notice that a particular harm is substantially certain to result unless the federal government changes what's going on. So again, can the plaintiff establish that there are facts available? So the issue for our case is, are there facts available that the federal government has known about what's going to happen with the systemic fossil fuel emissions? Well, let's start here. 1965, President Johnson's message to Congress. Carbon dioxide is being added to the Earth's atmosphere. By the year 2000, there will be about 25% more CO2. This will modify the heat balance of the atmosphere to such an extent that marked changes in climate, not controllable through local or even national efforts, could occur. What other evidence do we have? Well, here's a memo from the then science advisor, Pat Monahan, to John Ehrlichman in the White House, 1969. Carbon dioxide problem. He talks about apocalyptic change. This in turn could raise the level of the sea by 10 feet. Goodbye, New York. Goodbye, Washington, for that matter. And then a follow-on report with Nixon, 1970. The quality of the atmosphere may well determine whether man survives or perishes. And here we've got a timeline of the federal government's long-standing knowledge. 1955, Roger Revelle, director of the Scripps Institute of Oceanography. Increasing CO2 is linked to climate change, rising temperatures, and hurricane frequency. I went over some of these before, but we've got Dr. James Hansen, and Dr. Hansen's one of our experts in our case. He testifies before the Senate that the warming will cause more frequent and powerful storms, floods, and heat waves. In 90 and 91, there were reports to Congress, and these reports are massive, of the policy options that are available to stabilize CO2 at 350 parts per million. There's a substantial amount of knowledge. I love waving this report around. This is a report of the Environmental Protection Agency, 1983. Can we delay a greenhouse warming? And this report, written by Steve Seidel, goes on to talk about how it's essentially our country faces a total disaster unless we go about doing things to change the fossil fuel system. And what he concludes is pretty amazing for someone to put in an EPA report. The conclusion is we absolutely have to do this. There's no question that we have to do it, but it's politically infeasible that the votes aren't there to change the fossil fuel use of the United States. It's politically infeasible. The science dictates that we have to do it. That's what they concluded in '83, but the politics won't let us do it. There's another report, the Government Accounting Office, the General Accounting Office, to the Senate. Global warming, emission reductions possible as scientific uncertainties are resolved. And this concludes the threat of enhanced global warming in and of itself should serve as a catalyst to take action now. So let's go back to our Henry A. case. Let's go back to our Castro case. The government has known it needs to take action now. But now was 83. Now was 90. We've even got a New York Times interview with President Obama saying it's terrifying in 2016 what we are facing. So is this a due process violation? Well, again, our judge has found that there's a right to a climate system capable of sustaining human life. But even if you don't have that right, even if that new right doesn't exist, there's also rights to what prior decisions have held to be personal security and bodily integrity. Again, what's going to happen to our kids and future generations if we don't do anything substantial now? Well, as Julia alluded, back in August 2015, we filed a complaint. And our complaint sets forth all our claims, and the claims are based on certain facts that we allege in various paragraphs. When the government lost its motion to dismiss, the federal government had to file what we call an answer. It had to either deny what we claimed in our complaint or admit it. So I'd like to read to you a couple of the admissions the government has made in light of our complaint. The government admits that it has known that of the growing body of scientific research on the effects of fossil fuel emissions. And the government also admits that the pollution it is enabling endangers the public health and welfare of current and future generations. The government also admits that the consequences are already occurring and will become more severe with more fossil fuel emissions. And finally, the government admits that what's occurring now, what the federal government is enabling as well as acting on, threatens human health and the natural environment. There's a number of times where the government admits that our plaintiffs are being threatened and that they're going to suffer physical harm unless, and I'm quoting here, there is stabilizing of atmospheric CO2 concentrations through deep reductions in CO2 emissions. So the government has in essence admitted core elements of our case. And the issue's going to be, and we'll talk about it in a minute, what is the effect of these admissions? What is the effect of the government's knowledge on the ability of the court to fashion a remedy? But another one of our claims involves equal protection issues, and to that I'm going to turn back to Julia.
A couple more minutes before I turn it back over to Josh and Julia for some comments. And so I mentioned before that young people are being discriminated against. So this is just a graph that's a little bit hard to see, so we'll skip that one and look at this one. These are projections based on if the Clean Power Plan weren't being repealed and if it were being implemented. The middle column shows with the Clean Power Plan the makeup of our energy in the United States. And right now 80% is fossil fuels. So it would have dropped by maybe 1% or 2, but all the way out through 2040 with the Clean Power Plan or without, the vast majority, over 75% of our energy would still come from fossil fuels. And the Energy Information Administration of the Department of Energy didn't project really any significant reductions in emissions. And why does that discriminate against young people? Well, what our government does when it's making decisions about national energy policy and regulations is it does an economic analysis, and they use discounting rates. And for the economists, there were some economists in the room earlier. Are you still here? Well, there's one. So I understand there's this principle that an economist by the name of Ramsey articulated back in the day. Anyway, and what Joseph Stiglitz, who's one of the experts we work with, explains to us is that this idea of discounting the value of the lives of future generations over the value of our lives today shouldn't be done in situations when there's such significant risk posed to those lives and the resources they depend upon. So the discount rate that's being applied is one of the things that we're bringing in as evidence of discrimination in our case, because on its face it is discriminatory against young people and future generations. And so the question is, well, what are we seeking in the case and the ultimate remedy? And we are not seeking any kind of money damages. This is not a case where the youth seek to be compensated. They're really seeking a remedy that will be meaningful in getting the United States to reduce our emissions and get off fossil fuels according to what the science dictates. So Phil mentioned Dr. James Hansen is one of our experts, and he and other scientists have really established, both through looking at the paleoclimate record, doing modeling, and also looking at observations of what we're already seeing in terms of impacts, that even 1 degree Celsius of warming is dangerous for our systems. And that 2 degrees Celsius, which is what the international community has talked about for decades, is highly dangerous and will result in catastrophes. And so Dr. Hansen has established a prescription, and it touches on the things that Josh talked about earlier, which is you need a standard and you need a timeline, and these things need to be enforceable. And so we're asking the court to establish that to protect the fundamental constitutional rights of youth, that the atmospheric CO2 concentration should be no higher than 350 parts per million by the end of the century, which means we need to do a couple of things. We need to have very significant emission reductions, and we need to have sequestration with carbon drawdown. And we're not focused on engineered drawdown because, one, the technology is not really there, and two, it's massively expensive and it could cause other impacts. We're talking about biological drawdown. And in terms of energy, I think you all know it's the choice between fossil fuels and renewable energy. For biological carbon sequestration, it's really about changing the way we manage land and we practice agriculture and forestry, and starting to protect the soils and wetlands and forests that really are our carbon sinks and are essential to protecting the future. And I love this image because we're lucky we get to work with all these experts in all these fields. And what the technological experts and the engineers tell us is that the technology is available, it's been available. We do not need to be doing what we've been doing for the last 150, 200 years. And so we need to evolve. And that's really what the case is about, is evolving with science-based standards, requiring the federal government to prepare a comprehensive climate recovery plan. They set the policies. We're not asking the court to set the policies. We're asking the court to set the standard and order a plan. And fortunately, we have some great precedent for this kind of systemic remedy in other constitutional cases, including Brown versus Board of Education, and the California prison litigation is an example we point to a lot. So for those of you who aren't familiar with it, prisoners sued for 8th Amendment violations for cruel and unusual punishment because the California prison system was at 200% capacity. And so the prisoners went into court and said, our basic needs aren't being met, and this is a dangerous situation for us. And the court issued a remedy They heard expert testimony on what levels of prisoner population would protect the rights. And what they decided is that 137.5% capacity could still protect the fundamental rights of the prisoners. And they ordered California to get their prisoner population to that level. And they said to the state, if you don't do this, the court will release prisoners. And that was upheld all the way to the US Supreme Court. So there are really good examples. And what District Judge Ann Aiken said is that the judiciary must not shrink from its role as a co-equal branch of government. And that's really important when it comes to fundamental rights of especially young people. They can't vote, they don't have money to lobby, they don't have political power. They are the politically powerless group of people who will be the majority one day, but they don't have an ability to protect these rights but for our courts right now. And so they're standing up, and I just want to, in closing, say, this is not just a case. This is about what Josh talked about earlier, and it's really about paradigm shift. It's about not the laws, but the law, and having it have meaning for people, and going back to thinking of government as the tool that helps protect those things and the liberties that are most important for our lives. And so we do media work to elevate this story through communications, and we let the young people speak because they truly are the best spokespeople on this whole issue. And so thank you very much. I look forward to the conversation that we're going to have.
So I think Josh and Julia have some brief remarks, and then we could have a general discussion. So thank you very much.
I'll be brief, so why don't I go first here? All right, so I did something that I'm not sure anybody's ever done before. I was asked to give remarks and a response, and instead of preparing a response, I actually waited to listen to what was said so I could actually respond. It may be a terrible idea, but I didn't have as much time as I had hoped. So I mean, as may seem obvious, I think this is incredible litigation, and I think this is really, really critical, both from a legal point of view and, as Julia pointed out, from the sort of political point of view, from the idea of the law. So I'll just make a couple quick comments. Maybe I'll go from the end to the beginning, thinking about the law, and then going a little into the beginning and some of the specifics of the claims, which I don't claim to be a particular expert in. So I think the comparison to Brown is an apt one, Brown versus the Board of Education, which declared that separate but equal was an unconstitutional concept, and perhaps uniquely importantly to the parallel here, Brown also demanded specific systematic action by government as opposed to just ceasing action or monetary damages, etc. Not that monetary damages are common in constitutional claims. Brown was an incredible victory, and I just wonder, I mean, of course I have, both legally and socially, I have great love for the decision. I wonder, historically, looking back, if we look at Brown as an effective political victory. It was definitely an effective institutional victory. But I wonder how much of the political strife we see today actually stems from the real hatred for Brown, the real hatred for people of color, frankly, that existed and then was allowed to surface because of that. That is not at all to say that a good legal decision should, a court should shirk its responsibility, its co-equal responsibility, because of the potential political backlash. But it's something to think about. I ultimately think it probably doesn't matter. I think that cost is worth the right legal decision. We have to be able to have a system that functions despite the potential unintended negative consequences. But it's something that I do think we need to keep in the front of our minds. And as advocates for youth, for humanity in general, both in an environmental space and other aspects of human rights, we have to be prepared for that so we can figure out how to deal with it. I don't know how to deal with it. It makes me think, I should also say that it may not have been Brown that is really the problem. It may have been the Civil Rights Act or various other things that happened between, the 50s and today. But of course, President Johnson was famous for saying that the Civil Rights Act would mean that the Democrats would lose the South for the next however many generations. The recognition is important, but an action plan. It sounds like, I presume, not knowing enough about the history, that Johnson didn't have an action plan. So maybe what we need is an action plan to go along with the legal plan. So two more comments. One, I think the knowledge issue here is so incredibly important. Again, this is not my area of scholarship, the Fifth Amendment, 14th Amendment, equal protection and due process, but it strikes me that the knowledge is for the theory of the case and the narrative of the case is about as critical as you can get. The fact that we knew that, I did not know, but that the government knew, that scientists knew, that, you've all hopefully heard about the Exxon New effort and that additional litigation there. That knowledge is just so powerful to me, and it's powerful in some legal respects. It's also just so powerful rhetorically. So I think that is just we cannot minimize how important that is. If this were a tort case, which I presume it's not for various good reasons, including sovereign immunity, but if this were a tort case, that knowledge. The knowledge factor would so instantly switch off. It should so instantly switch off the political question doctrine. So right now, courts have the opportunity. Not unfortunately. It's a good principle in many respects, but have the ability to say this is not a question for judges. This is a question for the political system. And there's opportunities. There's times when that is a very important principle. But when you take it in the torts context, when you take it from inaction to knowledge and inaction, you really take out that political question and you make it a matter of fraud, not a matter of passivity. So it's a little less legally relevant, I suspect, in the constitutional context, but those marginal legal issues that are on the margins of the key legal claims, like knowledge, I think have probably as much impact on judicial receptivity as the central legal claims. And what I hope at least that will do in this case, regardless of the ultimate substantive review, will force the judiciary to say, we're going to address the substance of this claim. We're not going to literally and sort of rhetorically dismiss this whole concept because we want to call it a political question. Because it can be both a political question, which it very definitely is, and the judicial question. And that's, I think, absolutely what we have here. And then I'll end with the establishment of fundamental legal rights. I think this is a thing that can make people very nervous. Maybe not people in this room, but it can make people very nervous. And I guess the fact is, there may or may not be novelty here, and I don't think it matters, because I think we've seen in the history of constitutional rights-based litigation and decision-making is what seems crazy at the outset doesn't necessarily end up being crazy in hindsight. So I don't think this sounds crazy at the outset, but I hope that in the future, these kids that you're representing, when they end up in law school, some of them, hopefully not too many of them, when they end up in law school, that besides the personal connection, none of their colleagues in their classmates will look at these claims and say, well, that's crazy, how could they ever thought that? That it'll look to them just as natural as it looks to us to say, we don't discriminate based on race or, I was going to say gender, but we actually can sort of discriminate based on gender, so that's a bad example. So, sorry, it's a bad place to end, but I'm going to end there anyway.
Okay, thank you. I think, I was very impressed when I saw the complaint that I read it. And I think if we have looked at it from a European legal system, there are a lot of parallels. And I think we can, I think it is important. It is interesting. Thank you. It's interesting to have a look at these possible parallels to the agenda case. Because, first, or just in general, maybe not sticking very much to agenda, just general. First, I would say that these life, liberty, and property, these freedom rights, we have very established practices in Europe that they have to be protected in the sense of the positive duty by government, by law. And I think, as you mentioned in your complaint, that government is actively contributing to these greenhouse gas emissions. You mentioned this 1992 Energy Policy Act. I think you have a very good argument just to directly say that they're also responsible. And I think, in addition, we could also think of international law. I mean, the United States in 1992 has ratified the UNFCCC, the UN Climate Convention. And if there in Article 2, the parties committed themselves to the stabilization of greenhouse gas concentration in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate system. So if they do that, like in the international level, I'm sure they also want to protect their citizens. I mean, we could also have, we could also say, like from a lawyer's perspective, that although these state treaty rules have been established for an interstate relation, such commitments should have a weight in the design and in the interpretation of the internal law of the United States. The duty to protect. So I think this is a very important point because of these fundamental rights. Then I also wanted to do this, to talk about this parallel to this agenda case. And we have there the court, the district court, that says that it is established that if we don't mitigate, that we can keep this global warming well below 2 degrees Celsius, a catastrophe will happen. And this is established fact. So my question, and also make my recommendation to let courts here know that European courts consider this as established fact. Then I wanted to say also concerning this argument concerning the 14th Amendment or the Equal Protection Clause. Like in Europe, we don't have a cross-generational equality provision that would work. It has not yet been established at the constitutional level. However, again, approaches to future generations may result from the protection principle of the UNFCCC. Again, international law. So we have a protection principle in this convention which the United States ratified for present and future generations. And here, this fairness principle in the Urgenda case was directly applied. They said to the principle of fairness, the Dutch court has derived that the obligation to divide costs between current and future generation. So they say there is now a need to act, and there is now better room for maneuver according to current knowledge. So they act now because of this clause in international law, and we saw that this international climate law has a reflex effect on the interpretation on the national law. And my hope maybe is that this could be possible as well in the United States. Okay, and I think, I was talking in the morning about this implicit liberties, as you have it in the 9th Amendment. In Europe, like the interpretation of Article 8 of the Convention of Private Life has led to a wide interpretation in the sense of a general constitutional right against environmental damage. So this is very open. And I think there is a lot of potential also to widen these interpretations, like, for example, property or other classical constitutional rights. And even with this 9th Amendment, I think there we could also have a chance to find a new right, a fundamental right against suffering from the adverse effects of climate change.
I wanted to make 2 comments and then turn it over to Julia. The first is the current status of our case. We have a trial date of February 5, 2018 in Eugene, Oregon. but the proceedings are being now reviewed by the Court of Appeals. For us, the Ninth Circuit Court of Appeals, they're being reviewed on what's called a writ of mandamus. And if you want, I can explain that to you later. But so the current state is we have a trial date. It's February 5, but we're waiting to hear from the Ninth Circuit. And then another point on Brown that our trial judges have emphasized, and is really fundamental to Brown, is that in Brown, the evidence was that the separate but equal policies through scientific expert testimony had shown that the kids who were in the African American schools were being adversely affected by the conditions in those schools. And the point I'm trying to make is the scientific evidence that formed the basis of Brown was about harm to children. And they had testimony in the courtroom about that, and that was very fundamental. The states in the underlying trials did not contest that, so it was uncontested when it went up to the Supreme Court. And where I want to go is our kids are going to be relying on science, including the effect that climate change has had, is having, and in the short term will have on our kids. And that's going to be a key component of the testimony at trial.
Yeah, and I think your comments about Brown are really important and good to think about the political context of Supreme Court decisions. So one thing that people who haven't studied that period of the Civil Rights era and Brown versus Board of Education may not know is that at the time Brown was decided, only 30% of Americans supported desegregation. 70% still wanted separate but equal, if that, right? Some didn't want equal at all. And yet, so the court was stepping out ahead of where the public was and ahead of where, it was safe to be politically. And it was a risk that the court took. And I think what happened, from that decision, it took some time for the people to catch up to where the court was at that moment, which may have caused some of the tension that you discussed. And there are many other reasons, I'm sure. But I want to give you another example, which is Obergefell versus Hodges, which is our decision about everyone's right to marry, whether you're gay, straight, whatever. And that decision came down at a time when there was much greater public support for the right of all people to marry. And I think as a result, it has perhaps been accepted more by the public. It'll be interesting to see what public reaction continues to be as time passes to that decision. But the point I want to make about climate is that we have a majority of people, even in the United States, who understand climate change and are demanding climate action today. So we are not in the Brown situation. I mean, we're well beyond Brown, and then if you look globally, it's even more significant in terms of people's understanding of the issue. So I hope that by the time we get to the Supreme Court, that there will be this understanding by those 9 justices that this is not just the legal moment and the constitutional moment, but actually the political moment for the court to step in. And it's well past time actually for that to happen. And then Julia, on Urgenda, Roger Cox is one of my colleagues and heroes, and we actually were speaking to one another years ago. He wrote his book, Revolution Justified, and sent it to me and said he was inspired by the work that Phil and I and our Children's Trust were doing. And so we collaborate and partner and talk a lot about our cases. And the one point of disagreement that Roger and I have had is about the scientific standard that he chose to put forward in his case, which was the international target of holding warming below 2 degrees Celsius. And he actually had Dr. James Hansen come, and he very much understands the science of 350 and 1 degree. but because he could hold his government legally to that 2 degrees threshold, he chose to focus on that. And in part because by doing so, he could shut down the coal-fired power plants in his country and actually get their emissions going in a very significant direction downward. But the reason why I struggle with that is I think whenever we have courts or bodies articulating a standard for protection, that we don't want some courts saying 2 degrees is okay, or that 1.5 is okay. We need courts really understanding and facing the science and setting standards that can be precedential for other bodies, judicial bodies and other legal bodies around the country, around the world. And so when we work with our partners in these other cases, like the case that's going on in Norway, also on behalf of young people in Sweden, and the cases that we're directly supporting, getting the science consistent and straight and having the latest, most up-to-date science in all of these actions, I believe is very critical. But on the legal front, Roger and Phil and I were all simpatico. So it's, he used a tort theory, but the underlying arguments and actually the ways in which you prove up our two cases are very similar. It's the duty of care is established by tort law in the Netherlands, and here the duty of care is established through our Constitution and the public trust doctrine. And so I think and in fact, the court in our case cited to the Urgenda decision, and we're starting to see this in the cases that we are working on where courts are citing to one another internationally and domestically. And so even though international law is not highly respected in US courts and in our federal court system, unfortunately, which is why we can't bring a claim and win it, in my opinion, under the United Nations Framework Convention on Climate Change. Even though we ratified that, we didn't then implement legislation or enact legislation to implement that ratification. And so it's a legal barrier for us. It's a little bit complicated in the United States. But to me, the language in the UNFCCC is a government admission about what government's duty should be in the face of climate change. And it does articulate the public trust principles of intergenerational justice that I believe can be used in any case around the world, that all governments are trustees, whether the public trust doctrine is written in your constitution or in your common law or in your codes. It has its roots in these basic laws that all nations are subject to. So I wanted to point that out as well.
Very good. I'm sure there are many questions, so I have myself a few. I'm gonna wait in line. So let's go in that order right there.
Okay, thank you very much for your wonderful talk. I have a question about the law and democracy. And what makes me a little bit worried is that the cases you presented, so with the foster children and with the man in the police cell, well, they were actively put in care. And now comes my case from my country, from Germany. Because you base your argument on that it's well known that climate change is dangerous. So in Germany, it's very well known that fast cars driving without speed limit, it's very dangerous. And there has actually been an accident. There was a woman in a small car. She tried to overtake a lorry. And from behind there came a BMW, an SUV, and took her off the road and she was dead. That guy went without sentence. He was not guilty. Because the political will is that there is no speed limit. And now the question is, what could the government have done? Because they knew that if there is no speed limit, it's dangerous and these cases are going to happen. So that it's obvious doesn't help. So I think the case is here, what Juliana mentioned this morning, that you can prove that the government should have had the chance to take action, And I think in the speed limit case, they could simply say, Well, we're very dependent on the political will, and the people did decide that there is no speed limit and we couldn't do anything as the government. So what would you say in the case of climate change here? So if it's politically not feasible, then there has to be a point like saying, well, that can't be part of political decision. The government has here whatever calls to act on. Yeah, even, and there was one case that you mentioned as an example against the explicit political will of some party or whatever.
People go on. Our case is that the government has actively participated in the fossil fuel system. A classic example for us are federal coal, the mining of coal on federal lands. The government is permitting that at a cut rate so that there's no question that the government is enabling by letting the coal companies onto the land, that the government is permitting, the government is doing things beyond just building a road and then standing back and let whatever happens, happens. And so it's creating the danger in our estimation.
Yeah, and I would also, one other distinction, I think the judge asked me a question about speed limits at oral argument, actually. Or maybe it was a moot court, but it came up. And one other distinction is you could be someone who lives off the grid, doesn't have high emissions, or wants or really desires to get your energy from renewable sources, and or like children who aren't responsible for this, and they can't escape the climate system, right? And they can't escape our energy system unless they want to go without energy, and in many places. And so you could choose not to drive on the roads if you wanted to, or you could choose to get in your car and drive. And there's a lot of individual factors at play there, so it's another just piece that distinguishes the result of what our government's doing. You don't have to be an active participant in our energy system, and you're going to live with the climate dangers that our government has created.
Yeah.
Hey, thanks. Start with the fact that I really like what you're doing, but I want to be critical, I think, coming from academia. So I see all across a kind of only victims narrative, and that's, if you look at the two cases you brought forward, you're looking at the government as something objectified, that the plaintiff is not part of. And what I'm trying to understand here and maybe have a discussion about is the fact that these children are participating children, and we're talking about also young and adult people that use fossil fuel. They have a political involvement. So when you're talking about the political dynamics, you always talk about something outside their locus of control, and also the government is something outside. And for me, there's no such distinction. I mean, it's a very nice narrative to discuss, and it's a very nice way to kind of shift the responsibility. I'm just thinking in the long term, if you win this case, the consequences will be obviously to reduce the ability of these people to do something that they're currently doing. So the first question is, what do you see culturally? How do you see this will be accepted by the same youth that are now suing the government? And the second one, what are the consequences in terms of our society as seeing the government as something legitimate rather than something that we're just shifting the blame for something we're doing ourselves?
Well, I guess, so I want to let other people respond. I'll just respond in one way, and that is to see the third branch of government or the judiciary as outside of government is flawed. Right, so the fact that these young people are going to their third branch of government, they are actively engaging and embracing their democracy and their government, and they're asking the court, which has the greatest potential to help protect their climate system, we need your help to protect these fundamental rights, because we see that these other two branches are not going to. And so I just would contest that this isn't about embracing government. This very much is about having young people be very active citizens and engage their democracy in full. And in fact, they go to all three branches. These kids are amazing. They're some of the most amazing people I know. And they are engaging all three branches, including the courts.
You tell me.
Yeah, okay. Okay, no, I think, yeah, Thomas, they're there. Okay, good.
So I wanted to probe the phrase without due process of law. And so nobody can be deprived of their life, liberty, or property without due process of law. And I want to see what is meant by this qualifier. So I was also thinking of the traffic example, where you might say people are every day deprived of their life. People die to the tens of thousands every year on American roads. And you might say that this is justified because there is due process of law. This was properly decided by the legislature in the name of the people. The people made a decision to pay a certain price. And contrary to what you just said, Julia, I would say there is a strong parallel between energy and traffic. It's very, very unreasonable to demand anybody to not be in any danger of the traffic system, right? You have to stay home, you can't cross the road or anything like that, which is just as difficult to do and just as forbidding as to live without energy. So why do these two cases, why do you think they differ, and why do you think so it's okay for us to have a traffic system even though we know that 30,000 people every year will die in traffic accidents? And how does this phrase without due process of law come in here? Why isn't it a sufficient justification of the system that it was democratically adopted and justified?
Do you guys understand? Because I don't want to dominate.
I can weigh in a little bit on I think the relevance of the due process issue and just say a couple quick things. So maybe you know this, and then part of this is a rhetorical point as well, which makes sense. But due process means essentially two things in the constitutional sense. It means what is redundantly called procedural due process. That is, there are literal processes followed before there is some sort of deprivation. And then there's substantive due process, which I'll return to in a second. So the procedural due process basically says that the government can do pretty stupid things if it chooses to do stupid things, as long as they go through the right steps, and those steps give the individual who is being harmed roughly speaking, some opportunity to speak for themselves or to hear the evidence against them or whatever the case may be. At the legislative level, at Congress, it's generally agreed that the legislative process, and I think that's what you're saying, the legislative process, the democratic process is due process. So Congress can do stupid things, and the process that the individuals who are harmed gets to protect them is the ballot box. There are some exceptions on the margins, but generally that's true. So they can do stupid things if they want, up to a point. And that's where sort of the substantive due process comes in, and the idea that you can do stupid things, but they have to, what we basically say is they have to be rationally related to some government interest. So you can't just do something that is nonsense and does not even affect what you intend for it to affect. Or if it affects a fundamental right, which is what we hope we're dealing with here, then it's not just that it has to be rational, but it has to be a very compelling government interest, and the law, or I guess inaction, that creates the individual harm, that infringes on the right, that action has to be it has to be very narrowly tailored in the way that it advances this very significant interest. So all of that is to say that there is an argument that the legislative process is due process, but that's usually an argument for saying, we look right now at the things that the legislature is doing that seems improper. They're not debating issues. There's the Congressional Review Act is something that's a big issue now, which I won't get into, but essentially allows Congress, without offering any explanation, to just sort of snap its fingers and not only overturn administrative rulemaking, but also prevent any future related administrative rulemaking. And people want to say, well, that's not good lawmaking. And it's not good lawmaking. It's not good process. But procedurally, we just sort of let them get away with that. If we don't like it, we have to vote differently. But substantively, when we're dealing with something like the right to life and property and to a safe and sustainable atmosphere, which is not exactly the words you're using, but something like that. The point is there's substance there that we have to protect, and it has to, if it's going to happen, it has to be if it's going to be infringed upon, it has to be done in a very precise way. And I guess that simply deciding not to act is not a very precise way to deal with the huge fundamental issues that are at stake for the future of the world.
So I'll just add, just briefly, just so everyone knows the standard that the court will apply to the government actions in our case, and that if you brought a constitutional claim against the way traffic laws are set up, is the action of the government narrowly tailored to further a compelling government interest, and the defendants have to show that there was no less restrictive alternative available. So there wasn't another alternative that would have met the compelling government interest. And so in the case of climate change and climate dangers, there have for decades been alternatives available to a fossil fuel-based energy system, because providing energy for people is a compelling state interest. But they haven't used the most restrictive way of doing that to protect these fundamental rights, the limits on the fundamental rights that the government is perpetuating. So in the transportation system, it's a deep analysis, because our right to freely travel is one of our fundamental rights. So you're up against that right, along with personal security, and you'd have to really weigh government conduct, and is it reasonable? Is it achieving a compelling state interest in a narrowly tailored way? And you'd have to look at the evidence and really see what they're basing their decisions on. Here, government action is so egregious in the face of this irreversible harm that could make the planet uninhabitable. So it's at such a different level of impact that also distinguishes it.
Can I ask a quick follow-up? If you cannot get the decision you want on determining this is a fundamental right, do you think it's egregious enough that you could succeed on a rational basis at review?
We're prepared to make that argument, that children as a class are being discriminated against, even if it's not deemed to be a fundamental right, and that discrimination rises to such a level that there's not a rational basis for it.
Hey, ooh, that's loud. First of all, this is amazing. I really have vast sympathy for what you're doing here. So take my observations as a mutual concern, I guess. First of all, my question is what do you hope to be the main outcome, even if you succeed in this project? I mean, even if you manage, if you're successful to kind of curb the actions of US government and corporations, what I doubt is actually impossible, but even if you succeed in that, I mean, climate change is a global problem. CO2 emissions do not only stem from the US, I mean, China, India, Russia, and so on. It has to be dealt on a global level. So it even means, if you tackle the issue here in US, what is doubtful, because of the major interests that corporations have and the interconnection between the corporations, profit, and the governments, and so on. I mean, that's just the first step in actually tackling the iceberg. I'm referring to your slide from the presentation. So do you have any thoughts on that?
Sure, and I'd like to start off by pointing out that what our remedy is that we're seeking is, first, let's figure out where we are. Let's do an inventory. And then based on where we are, much like in the desegregation cases, or as Julia was alluding to, the prison cases, the court ordered the federal government to develop a plan that achieves the targets that the court determines are dictated by science. So the plan will not be some judge sitting down with a wig and a quill pen trying to devise how our federal government should work the energy system. Rather, our hope is that the judge will have the federal government design the remedy through a plan that then is implemented within a short period of time.
Right, and here's why I think it makes a difference globally. I mean, the United States is responsible for 25% of the emissions in the atmosphere. We've been reading thousands of documents, understanding how the United States has infiltrated this international process and really to destroy its effectiveness. And so if the United States, as the nation most responsible for the problem, and still the second largest emitter, and that's not even looking at our per capita emissions, and that's not looking at our fossil fuel extraction-based inventory when we export all of our resources, and it's not looking at our consumption-based inventory for all of the goods and products we import, right? So we're talking about one category of emissions that the U.S. is responsible for, that it reports. But in the case, we're actually asking the court to order a full inventory that looks at our extraction-based inventory, our consumption-based inventory, and have the full scope of the picture. And I would bet that we're still number one if you take into account all of that. So if you get the number one government preparing a plan where we're almost fully decarbonized by 2050, so no more, like 5% fossil fuels is what we're looking at in the prescription by 2050, and most of that happens in the next 15 years. That is significant for the entire global community, and other countries who have wanted to do more but haven't because of our leadership will step forward. And our hope and belief is that once judges begin to step up here, and in cases like the Netherlands and in other courts, that there will be more domestic enforcement of the largest emitters. Because the international process alone will not work, in my view. I think we need domestic enforcement, and we need accountability. And that has to happen in a nation-state by nation-state basis. So I'm hoping for a ripple effect.
So, right there in the front. Yeah, you two. Where was it?
Congratulations. It's a brilliant idea and amazing that you're defending a group of children and you take them seriously, which is not a common thing around the world. So my question is, could a similar case of suing the US government in the name of children go for arms production and guns ownership? And would that, I mean, the arguments would be even more obvious because then, when you produce guns or you buy guns, there's no question whether they are lethal. So could that kind of trial go for arms control?
Well, so in terms of domestic arms, the Supreme Court has recognized that the Second Amendment protects people's rights to bear arms and have guns. And so when you have situations of different fundamental constitutional rights butting heads, it becomes a very complex situation. And fortunately, we don't have that situation in our case, which I'm grateful for. And when you're talking about arms production that get delivered around the world, then you're entering into a national security issue, which also gets complicated in terms of the political question doctrine that we were referencing earlier. So your scenario, while important, presents all kinds of complications that we don't have, thankfully.
Hi, I would link my question to the previous question related to the outcome, because I was thinking of what's the best scenario, like the best outcome that you are expecting to get out of this, and then if you can please guide us through what will happen if you get to this outcome. I mean, operational, what will be the steps in terms of how the institutions would have to react or to act? Thanks.
Yeah, so the way it would work practically is the court would order the federal defendants in our cases, which involve numerous agencies and departments and the Office of the President, to prepare a plan that would achieve annual emission reductions in line with what the court orders the government to do. So they prepare a plan, the court would order a date by which it would be submitted to the court for the court's review and approval. And so if there were problems, we would come in and participate on behalf of the plaintiffs. The court also has options to appoint a special master or an expert to advise the court on these matters when it's presented with a plan. And then the plan would be implemented, and there would be annual or every 2-year reporting by the government to ensure the court that it's meeting the emission reductions that the plan is supposed to meet. So full implementation, and the court retains jurisdiction over the case during that time frame. So it's a long time for a court to retain jurisdiction, at least through mid-century, but it's not uncommon. It's happened in the treaty cases in the Pacific Northwest regarding salmon and tribal rights. And so that would be sort of the logistics of it. And many of you may be wondering, well, do we trust the Trump administration to prepare a plan if it's ordered to do so?
I'm wondering.
And we think a lot about this. So we're actually working with experts who are preparing the plan. So in the event that the government doesn't come forward in a timely manner with a plan that would work, then we can step forward with, here's an alternative to whatever they propose. And then I want to mention one other thing. So when Brown versus Board came down in the Civil Rights era, ultimately what happened was we had the Civil Rights Act, right, and the Voting Rights Act. And so Congress, while the court can't order Congress to pass legislation or, for example, enact a carbon tax, Congress can choose to step in and be a part of this plan by saying, we're going to enact this legislation that will help meet this constitutional mandate that the court has now set. So it doesn't have to just be the executive branch, but that will be up to the political branches and the public to try to influence. But they'll have this court decision on constitutional rights to be holding up as they do that.
And another point I want to make is, again, we're not, in this case, going after the states. We're not in this case going after private industry. So the plan would go to the operations of the federal government. We have other cases like Julia spoke about the Alaska case. We have other cases where our Children's Trust is proceeding concerning state governments under public trust theories and the like. But this case just goes to what the federal government is doing, is enabling, etc., and the plan will just be for the federal government.
And what it has control over.
Very good. Oh, I missed. Yeah, sure. Yeah, thank you.
Okay, two things. One is in terms of your argument that these people should know or should have known. You gave a number of examples. I've got two more examples to suggest in addition. I believe there's a European, maybe Dutch scientist named Arrhenius, and in the late 19th century, he's the one who predicted global warming, and I believe he won the Nobel Prize, and he died in 1927, 90 years ago. So in terms of knowing or should have known, which is the standard of negligence, which is the standard for tort, you've got that argument. And in addition, I guess there's an example of Gus Speth on the Council of Environmental Equality of President Carter. They issued a report at the end of Carter's presidency warning about global warming. And the thing about Gus Speth as an expert witness is he was also the head of the Yale School of Forestry and Environmental Studies, and also has a JD in law from Yale Law School. And another point, in terms of the idea of a social contract and the rights that go with it, in case you run across a Federalist Society judge, you've got the idea of Edmund Burke, and he defined the social contract as something made between those who are living, those who are dead, and those who are yet to be born. And an expert on that, on Burke, would be Ian Shapiro at Yale, who's a big deal on this campus. But Ian also has a JD from Yale Law School. And again, he's an expert on Edmund Burke. You know, if you cite Burke, you might be able to set a precedent, which might be useful in the future.
Yeah, thank you. We work with Gus Beth. He's another hero of ours, and we just found a carbon dioxide newsletter that the CEQ put out in, I believe it was 1979, that is an amazing piece of evidence for us in the case as well. And we have the scientific record going back to the 1800s and Arrhenius. And one thing we've done is created a timeline that goes through every presidential administration since the late 1800s and talks about what was known with climate change at that time. And while we don't have to go back that far in the case to prove our case, it is a very important part of our history that we're trying to get out there in the context of the case.
And another thing we're doing is we're sending people, primarily law students, out to presidential libraries to see the actual documents that are there and going through what each president knew, because you see the Jimmy Carter initials on the memo, for example, and it's fascinating what we're seeing. The memos to Clinton where he's initialing off on this is a huge problem that we have to address now.
Yes, thank you. What standard or threshold of available facts is your case being held to? And what drives your choice of Oregon as a venue?
Oregon.
I'll talk about venue, you talk about facts. So venue, the majority of the plaintiffs actually are residents of Oregon, and I live in Oregon, and so it was a matter of convenience for the plaintiffs, but also a matter of climate change impacts and some very important arguments about public trust resources, including the oceans off of the coast of Oregon, which are some of the most acidified oceans on the planet right now. And then there's another reason, which is one of the claims that Julia referenced is a claim that challenges a particular statutory provision in the Energy Policy Act. And there's this provision, it's one of the only provisions of law that Congress has enacted in our country that mandates that something happen with respect to fossil fuels. And what they've mandated in the Energy Policy Act is that if anybody wants to export natural gas to a country with which we have a free trade agreement, all they have to do is fill out this form and the Department of Energy signs off on it. There's no public review, there's no public interest determination. Like if you wanted to go and export natural gas, you could. And so we're challenging that law as unconstitutional as part of the systemic aggregate actions that we're challenging. And we're tying it to a project in Oregon known as the Jordan Cove LNG facility, which is going to be one of the biggest West Coast export facilities if President Trump gets his way. It was actually, the permits were denied under Obama, and now it's come back to life. And the power plant that they will build just to liquefy the natural gas for export will be the largest source of greenhouse gas emissions in the state of Oregon. And so it's an important part of the case for that reason as well.
And also from a standard standpoint, it used to be, it may not be interesting to most of you, but it is to me, it used to be we would have had to have proven a subjective state of mind for each of the government officials who we've named as defendants. The courts have now changed that standard, and it's objective. It's an objective. Did the federal defendants not take reasonable measures to address the issue? And one of the timelines that was up there, there was a report in 1990 that went to Congress of the various policy options available. And in the report, they talk about, well, this is the way we now, and this is what it's going to look like in 2015 if we continue on business as usual. And the numbers are incredibly accurate. And the report says, but if we adopt these policy options, we can reduce the issue substantially. And that's, in our view, the type of objective evidence that we have, where the government knew the problem, the government knew it had options to solve the problem, and yet the government didn't implement any of the measures. It adopted a business as usual approach, and as of 2015, when we filed our complaint, we were right in the danger zone where they said we would be.
And what's interesting, when a fundamental right is at stake in a constitutional case, once we've established that there's been an infringement of that right, the burden shifts to the government to prove that it has acted in a narrowly tailored way. And virtually none of those cases are successful for the government. They lose those constitutional cases.
Good. I have two questions. First, do we want the courts to set like really specific emission standards reductions? So, and if so, given that your target is more ambitious than the Paris target, if we set an emission standard that is more demanding than what the government, committed to in Paris, I suppose that's gonna have, it's gonna supersede whatever there was committed in Paris. We're gonna have something more demanding. So that would be my first question. And second, obviously I'm not trying to find a silver lining in the current administration, but is it gonna be easier to prove your case given that the government is acting in such a reckless way and destroying so many of the current potential, like current plans we had in place and current regulations? So is maybe the fact that we have the Trump administration right now gonna make it a little bit easier for you in that sense? Not that it's a good thing, but yeah.
So I'll handle the first question, Phil will take the second. So on the first question, first I want to be clear that President Obama did not commit the United States to anything in the Paris Agreement. Like legally, there was nothing that as a lawyer you could take and enforce. So President Obama had great rhetoric, and he had okay rhetoric. But even if you accepted that there was sort of an intention or goal of trying to stay below 2 and hopefully 1.5, we now know President Trump isn't concerned about that at all. But it was a goal, it was aspirational and not binding. And in fact, what's really shocking is we've been doing discovery. We've been asking in depositions and in other ways, has the United States government ever set a standard for atmospheric CO2 levels or for emission reductions? Or have we ever said, this is what will protect public health and welfare or the rights of the people? And the answer so far is no. Which to me is unbelievable, because if you don't have a standard, I mean, think water quality. We have water quality standards. We have other air quality standards. And we don't have a standard for carbon dioxide. So yeah, we're asking the court to set the standard that protects the rights and then order the US government to reduce emissions at least at the rate that is the global average necessary to be on track to get back to 350. And it's still doable, but we're in a matter of years where we're gonna hit a point where it won't be doable anymore.
And as to your second question, when we originally filed our case, there were a number of people, and I don't mean one or two people, I mean a number of people who said, we can't believe you filed this case against the Obama administration. It's outrageous that you're claiming the Obama administration is not doing enough to address climate change. And those same people are now calling us up, thank God you filed your case, because the Trump administration is now in there, and they're clearly showing deliberate indifference. They're clearly implementing policies that they know will injure these children, or the phone calls I get, my children or my grandchildren. And thank God you filed this case, because again, the standard is deliberate indifference, making policies that are contrary. As Josh said, the evidence is clear, and yet they're implementing policies that are directly contrary to all the scientific evidence.
First, I just want to make a comment that you said that in the case of Brown, the court was ahead of public opinion, but now public opinion is with you. It makes me think that similarly with the gun control advocates, public opinion is with some kind of regulation, and yet the courts have really not, or at least the federal government has not followed suit with what is obvious public opinion. So I'm a little concerned about that line of reasoning. Just a comment. I have a question about the issue of causality. This morning, the lady from Lucerne was talking about the probabilities. I suppose she meant of global warming coming from CO2 content. It's not necessary in my mind to establish a probability, because there is a certainty of the greenhouse effect. Now that is a certainty, like gravity. The actual outcomes on a short-term basis are not knowable, and people admit that right now. They don't know if Irma was because of climate or not, but they know that the number will increase. And similarly with greenhouse, that is gravity. It has to work, so the heat content of the Earth has to increase. How it will be shown is up for grabs. But if you want certainty, there it is.
Is it working?
No, I turned it off.
Yeah, okay.
Turn it on for you.
The point was not to say there is no evidence on that. The argument was just to say that even if there was no evidence, we could have legally arguments with the precautionary principle to argue for. You understand? We still have causality, even though it would not be sure. But if it's sure, it's okay too.
Thank you so much for the interesting presentations. I was just thinking when you were talking about the California prison case that there was this kind of very measurable number of prisoners that was justifiable, and also the kind of the deterrent that the court could order some prisoners to be freed. I was just thinking that with the carbon dioxide, it's much more difficult to measure the exact level and the kind of the impact that the U.S. measures have for that. So I was just thinking that how would the kind of the possible, if there's a victory in this case, how would it be enforced? Would there be some kind of loophole for the government to kind of prolong the implementation, and is there that kind of threats here as well? Thanks.
So I think in part your question is how do we ensure or enforce the emission reductions that the United States would be ordered?
Yeah.
I mean, it's not a perfect system, right? So the United States requires emissions reporting by industry and companies, and states have to compile inventories. And ultimately, the Environmental Protection Agency and the Department of Energy monitor those and verify that the emissions reporting is accurate. And I think it's a flawed system. There are criticisms of the accuracy of the system. And so it's something that we need to be vigilant about, is ensuring that we are using the best, most up-to-date emissions reporting systems that are available, that we're complying with sort of international standards on that, and that we're having transparency in government. So, I mean, one thing that I think we've been very concerned about as we've been preparing for our case are all the government websites that have either been altered, shut down, information that's been hidden, data that they don't want to make available. So there's going to need to be vigilance also on the part of the public in ensuring that we're getting the data and it's made available to us. But as I also mentioned, the court has the ability to appoint a special master or an expert who can help oversee that implementation process to make sure that the court has the information it needs to enforce an order if necessary.
So I think, was there, okay, very good.
I just a comment. I think it's fabulous what you're doing. Just to follow up to the last question, though, could an argument of the defense, the government, basically, be that sure, we can try to control CO2 in the United States, but we have all these other countries that are polluting at will, China, etc. Could an argument that they could make be that we can't control CO2 emissions? We can try to control it in our country, but if you try to set a standard, our lower CO2 will kind of act as a vacuum and vacuum up CO2 from other polluting countries. Is that a potential weakness in trying to have the government set a standard?
Well, they've made those arguments that the United States is just one country and it's a global problem, and that argument has fallen flat for them. And Phil might be able to pull out a nice quote to exemplify that. But I think the key issue is twofold. One, every sovereign nation is a trustee under our theory and is co-trustees over a global resource. Each sovereign has an obligation to do its part to protect the resource. So that's one part of it. And then the other part related to the state-created danger is we have government witnesses who say we're in the danger zone. Government scientists say we're in the danger zone. So once you're in the danger zone, anything that the government continues to do to push a fossil fuel-based energy system forward enhances the danger and makes it worse. And so it has to at least deal with its part of that danger creation at this point.
And two things in their answer, the federal defendants admit that the United States comprised more than 25% of cumulative emissions. So they admit that. We're not going to be arguing what I'll call, is this a substantial factor if you get the United States to control, because they're admitting that. But they also admit that stabilizing CO2 will require deep reductions in emissions. So they admit that there's going to have to be deep reductions. The question will then just be for the judge to work with the federal defendants to frame how you get to those deep reductions. But they've already admitted 25% and deep reductions are necessary. So for us, those are two key components of trying to then get to how do you get from that 25% to those deep reductions. That's what the judge is going to have to do when we're in the remedy phase of our case.
And I would just add two quick observations on the legal standard. So on the one hand, that argument that the U.S. can't do it all or can't solve the problem alone is an argument that's been made to say there's no standing. I don't know if that was our standing argument here, but in the 2007 Massachusetts versus EPA case, it's one of the arguments that the Bush administration made. We've only got a small piece of this, or a large piece, but a relatively large piece, but still small overall. So how can you can't claim that there's anything we can do to solve this problem. And the court in that case ruled you don't have to solve the whole problem in one fell swoop. Starting the ball rolling, getting the momentum moving is sufficient for meeting standing. So that's on the standing front. I think what you're asking is more of substantively, and I think this is more of an opinion than a fact, but if the court finds there is a constitutional obligation, the inability to solve a problem does not permit a government to violate what is otherwise a constitutional obligation. I would argue. Maybe these guys will too.
We would argue.
I can add that in the Urgenda case, this claim has been, this has been declined. The court did not accept this objection by the Dutch government, accepted the same objections.
So Daniele has a question, but yeah, if I'm not mistaken, just to jump on, I think the Dutch case, because the Dutch government made this argument, and there was a ruling, and in the Dutch ruling, they said, we're just asking you to take care of your own emissions. Every emission counts, and you have to reduce your emissions, and that's all we're asking, and it counts. And I thought it was a beautiful bit on the Dutch ruling, right? Okay, so we have time for 2 more questions. I think Daniele, and behind you.
Okay. Thank you so much. Your work is very important, and I thank you for this, and I will put this everywhere in my social networks, and if it might help somehow. So I'm very sympathetic, but my point is, you say that you have the science, and there is the public opinion, and there might be the law as well, and that's what you want to get. But the problem is that the law, whether there is the law or not, it's on a judge to decide, right? We have to win the case, right? And that's very important to win the case. The elephant in the room is the huge democratic deficit, that we can do this only through the legal process, but not through the democratic process. So I was wondering whether you would consider a crucial factor to propose a system of public finance of electoral campaign or presidential campaign, because that is what is missing. The Congress is completely detached from the political process. So we need to do what you are doing, go to a court, which ironically seems the last tool to save democracy.
Yeah, I mean, it feels like we have a crisis of our democracy, right?
Not just the U.S.
Not just the U.S. It's happening across the world, and part of what we are trying to help young people do is reclaim their democracy. And again, I think that the judicial branch is a very, very important branch, and the reason it was created by the founders of the U.S. was to prevent against majoritarian power that would discriminate against those who didn't hold the political power. So it's just so critical, and I hope that as these young people and these next generations who see these injustices, that they will want to reclaim their other branches of government as well and step up. That this is a platform for young people right now that's very critical.
And I think one of my law partners is Pete McCloskey, and Pete was responsible for co-founding Earth Day and passed the Endangered Species Act. But Pete made a fundamental point to me that we really can't get lost. He said, right after the first Earth Day, when the youth of America started to realize how important it was to be active on environmental issues, they targeted particular members of Congress, and they went after those members of Congress, and they were successful in getting those members of Congress replaced by others. And that sent a message to the other members of Congress that if you don't toe the environmental line, then you're next. And that's what's got to happen, because what's occurring in our country right now is if you don't toe the fossil fuel line, then we're going to go out and we're going to replace you with someone else who will get the backing of the fossil fuel people. We need the reciprocal of that going on out here, and that's got to be led by our youth, and we hope our kids and the social media that our kids are working hard on will get youth to be out there and be politically active and get the right people elected, because that's what needs to occur.
Yeah, but I will say, like, to every one of you in the room, young people, they need a platform. And so as adults, it's not just supporting them and empowering them, but really giving them a platform to speak out. And so I think every adult has an obligation to do that with young people in whatever way you can on these issues of social justice and climate justice.
For those of you who are students or otherwise involved with university, if you're organizing conferences, symposiums, and so forth, people prefer it when there are young people on the panels. It's more interesting than just us. We had Esau Sinnock, who's involved with your work.
The
he was,
Alaska case.
yeah, he's a plaintiff in the case from yesterday, right?
In the Alaska case.
Yeah, so he was here last year for the New Directions in Environmental Law Conference, and he was on 3 separate panels, and he was by far the most popular person in every room he was in.
Oh yeah, and the reporters, they don't want to talk to me and Phil, they want to talk to the youth plaintiffs, I mean, which is great, so, I agree.
Very good. Okay, there was one quick last question.
Just in response to the question about, so what if we do it, what about other people? You know, just to state the obvious and then a comment that's not so obvious, I think it's generally agreed that it's precisely because Obama moved, joined the Ambition Coalition to drive towards a standard of 1.5 Celsius and so on, that we managed to get almost every nation in the world signed on to COP21, right? The second thing is that in the in one of the regular political science seminars here, we had a person running models of climate clubs in response to our current president, showing that, well, what happens if only several countries act? What if we drop out? Or what if just several countries act? If the United States, China, and Europe, and I think India might have been in it, those polities alone can cover 50% of where we need to get. So we don't need to have everybody in the world come along with it, but we do know that when we act, we get a whole lot of other people to act with us.
Well, I think that's a great comment that's going to lead into our panel on politics at 4 o'clock, so stay tuned. But before that, please join me and thank you.